Namaskar and welcome everybody. It gives me immense pleasure to welcome you all to the Global Law School Summit 2021. Welcome panelists, colleagues, students to session number 15. My name is Alexander Fischer. I'm a professor in the Jindal Global Law School and I will moderate this panel for the next 1 hour. Our topic today is, well, the topic for this panel is the lingua franca of global law, legal language, and postmodern transformations. And right at the outset, I wanted to clarify one little detail. When I read lingua franca, I wondered what is the plural of lingua franca? And because certainly throughout human history, there were always a multitude of lingua francas or francae or franca. So I looked this up in Merriam-Webster's dictionary, Oxford Dictionary, and a couple of other places. So there are numerous ways of expressing that there's a plural of lingua francas. But I'm just going to say it right at the beginning in the spirit of global legal pluralism. And just to rebel a little bit, there are no rules for this panel when it comes to the plural of lingua franca. You can say francae, francas, or just franca. So I hope this little anecdote made you smile a little bit before I introduce the 4 scholars who are joining us as panelists today. I'm not going to read out their bios or their list of publications because then the first half hour of this panel would simply be gone. All of them are exceptional scholars standing at the apex of their field. And also what's very interesting for us today with respect to education, legal education, is that they're also at the apex of the institutions as deans, vice deans, or program conveners. So we're also getting an enormous practical knowledge. Sort of a habitus of global legal studies is present here in the room. I'll start with introducing Professor Lima Rego, Vice Dean of the Nova School of Law in Lisbon. And I'll just, for each panelist, I'll pick out one specific point which I think is relevant to the theme of this panel. She's practicing in civil and commercial law, but what I found really interesting is that she has specific expertise, of course, in Portuguese or Lusophone law. And then already we're back to the dimension of multiple lingua francas, because in India we also had a French colonial connection and a Portuguese colonial connection, right? And what is the status of Lusophone law today from a global perspective? I mean, this might be something that's very interesting for us. Also, as I think she's the only vice dean who is from a country where she is explicitly in charge of programs that are in the English language, right? So even the domestic legal education. So I found that's also very interesting for us today. I'd also like to welcome Professor Brooks, Dean of the School of Law at Durham University. I already knew him. He's an award-winning author, columnist. I read his work on migration and his work on becoming British. And so that would be one interesting angle. I felt that with global mobility, do we take along our language? Is the lingua franca, what is its relationship to the idea of mobility? And you're right to carry along, like in a little suitcase, you sort of your multilingual background. And is mobility not actually recreating, when we think about what does it mean to become British nowadays, isn't an idea of multilingualism not baked into all the diasporas that are living in the UK? Third member of our panel is Professor Contreras from the College of Law at the University of Utah. He also serves as the co-chair of the interdisciplinary division of the ABA's, the American Bar Association section of Science and Technology Law. And I found this very interesting, that he has such a strong interest in science, genetics, data mining, variables, because of course we could argue, we could think about technology as a different form of lingua franca, but then once we see the little cracks and scope of interpretation when lawyers and scientists are starting to talk to each other, what is the is the language of science a suitable lingua franca for law and globalization. Finally, I've gone through this alphabetically. Professor Karton from the Faculty of Law, Queen's University in Kingston, Canada. He's the Associate Dean for Graduate Studies and Research. So again, you can see how this practical dimension is always coming into our panel. His particular expertise is on international dispute resolution, especially international arbitration. And he's working how private actors from different backgrounds, legal, cultural, linguistic, meet in the international legal arena. So absolutely perfect, of course, for our panel. Also, he's worked not just in New York, but also in Hong Kong. He's fluent in Chinese, has taught in Taiwan. So again, sort of a dream set of panelists for the topic that we are addressing today. The first question that I would like to address to our panel is maybe sort of as a warm-up question, is maybe really related to the practicality of a lingua franca in a legal institution. It could be a domestic legal institution like the Indian Supreme Court. So the Indian Supreme Court once recently considered introducing Hindi as a second language, and the Law Commission brought out a report number 216, on the non-feasibility of the introduction of Hindi as a compulsory language in the Supreme Court of India. So the title already gives it away. Nobody really thought this was a good idea. And I think the word flabbergasted is sort of the right expression for describing how the Indian Supreme Court judges have reacted to this idea. So you can see the institutional backlash and resistance when it comes to questions about language. At the same time, there is an absolutely legitimate concern behind this report. And it's the question, do we reconsider whether English, is it appropriate that it is the only lingua franca for an institution like the Indian Supreme Court? And I felt that this anecdote from Multilingual India helps us to frame one of the core themes of this panel. On the one hand side, we have the postmodern sensitivity towards diversity, your right to speak in your mother tongue, language as an icon, as part of your identity. On the other hand side, we have all these practical considerations and institutional biases towards a specific lingua franca. Could be English, could be an Asian language, could be French. And this would maybe be my first question at this panel. When it comes to institutional design, how does it relate to lingua franca, and where do you see the spaces where English is dominant, or maybe spaces where we question the dominance of English? I haven't addressed it to any specific person, but
I could go ahead, Dr. Fischer.
Oh, that would be fantastic. Yeah, thank you.
Maybe just to say that, I guess this is a Canadian perspective. We are an officially bilingual country, and there is a right to access the courts equally in English and in French in Canada. But then there's also more recently been a question raised. I'm sorry, I'm getting a bit of an echo. I don't know if the audio is correct here. I seem to be in two different, is that better? Okay.
It's better now.
Thank you. Sorry about that. Microphone problems. Because Canada is officially bilingual, it I think drives home the idea that to establish more than one language as a language of the legal system requires a commitment, and not only an ideological commitment, but also a commitment of resources, of time, of money. It restricts who is able to sit on the Supreme Court, for example, and in the federal courts, and that there must be an assurance that they can hear litigants and counsel in both official languages. And that's something that's been brought home quite recently as Canada has come to recognize that it's not a bijural country, but a multijural country with a multitude of indigenous legal traditions as well. And the discussions of how to ensure access to the courts for people whose first language is an indigenous language has kind of foundered in the practical details of finding sufficient numbers of people who are fluent in those languages, who also have legal training in dealing with the costs of translating documents. I think probably the European Union has confronted this more than any other institution in recent years with so many official languages. All I would say, I think, is that there has to be a recognition that it's either you go big or you go home. If you're going to recognize multiple linguae francae, or however we're going to pluralize that, there has to be an institutional commitment as well as simply a political one.
Excellent. So that's definitely something I can take away from this and, leave it maybe later on for audience questions. The institutional commitment, the resources, either you do it or you don't do it. But the political commitment is not enough. Yeah. Professor Contreras, you had raised your hand.
Yes, thank you. I don't know if that's how you want to proceed on this panel, but happy to just do the little hand raising. So I certainly agree with what Professor Karton just said, and would just offer like the two contrasting perspectives of the United States and the European Union when we think about this. But first also to just raise the question and the issue of the term lingua franca itself, and maybe differentiate that from the concept of an official language. I mean, I'm not an expert and historian of this concept, but my general understanding is that the lingua franca is sort of like the lex mercatoria, in that it's a commercial concept that arises from voluntary use, as opposed to and primarily in trade and commercial transactions, as opposed to imposed on the populace by edict of the government. And there are, I think, different considerations at play. In the commercial context, this is purely a question of efficiency, and actors and markets will use whatever the most efficient mechanism is for them to transact business. How they will, if they're all English speakers, for example, then they can conduct their business in English. If they're not, yet they still want to do that, well, then they will bring along translators, or any number of possibilities to make the transactions work in an as efficient a way as possible. But it's a different question when we're talking about a democracy and the linguistic imperative to ensure that the citizens of the democracy understand the law, understand the laws that bind them, and that they're expected to comply with. And that, I think, is a much more important discussion, honestly. And so maybe we use the term lingua franca there for lack of a better term. But I mentioned the term official language because in the United States, there is, contrary to what may be the popular belief, there is no official language in the United States, despite all of the rhetoric and make America great again and all of that stuff that we've heard over the past many years. English is not an official language of the United States, certainly at the federal level. There have been innumerable efforts to make English the official language of the nation, starting in the last century, 2 centuries ago, but those never have been successful, often because of the implications for discrimination against those who don't speak, and especially as a country created by immigrants. There is an understanding that at least for some period of time, many people who are in the United States do not speak English or do not speak English yet. So in our system, our court system and so forth, for matters of convenience, judicial opinions and proceedings are conducted largely in English, and opinions are certainly published in English. But for non-English speakers in the lower courts, we have dozens of language translators available to translate the proceedings. These are primarily criminal cases where the parties may not be English speakers. Again, that's not official policy of the nation, but it is implemented at the local level. There are US states that have adopted official language legislation, mostly in the last 20 years, and largely for political reasons. But it is interesting to note that a number of those states have more than one official language. Several states have Spanish as a second official language. 2 states have French recognized officially, and then a number of native languages have some degree of recognition, and certainly within the tribal territories that are federally recognized territories within the United States. So it's a very complicated landscape. And so even without translation of court documents into other languages officially, there is some effort to ensure that citizens have an awareness of the law. And I know we have Europeans here. I would only contrast, I think the extreme example of language pluripotentialism is the European Union, of course, which has 24 official languages. There is a right to be heard in any one of those 24 languages at the European Parliament. All official European documents are published in all 24 languages, which is hugely expensive. I don't think the Canadian example there's a resource issue here. There's an enormous resource issue associated with the European system. And there, that again is a cost that seem to be worth paying in that system. So anyway, I will stop there and let others go, but thank you for the time.
Fantastic. I mean, just sort of to highlight some points, 2 points where we maybe can come back to. In India, it's just the other way around. There was a very careful avoidance of a national language because of a North-South conflict. Hindi would have not been suitable in the southern states. And there they've opted for the official language for the practicality, but avoided the identity aspects of deciding what would be the national language. So I found this quite interesting to see. So on the one hand side, we have the rule to use a specific language as sort of as a command of the sovereign. On the other hand side, if you have pointed out, it's also often just a question of practice and choice of the actors. What is the most efficient? Yeah. So that I found really, really interesting, the distinction between voluntary and as a rule. How do we distinguish there with lingua franca? I think that's something which we need to be aware of for the rest of the panel. Thank you so much. I'll just follow the order of these hand signs, and I would like to ask Professor Brooks.
Great. Well, thank you very much. And I'm a fellow American from New Haven, but I've been in the UK for 20 years, and I've become British, and I literally, I guess, wrote the book on becoming British, as you kindly mentioned before. But so long may my native country not have an official language. I hope that does continue. And there's a fascinating point raised by Professor Contreras, right? That this movement in America to have a kind of a English as the official language is really kind of a more recent thing. Though I bet you when you speak to folks who argue for this, they're claiming that they're not doing something new, that they're somehow reclaiming some kind of past that never was. And I make that point, yeah. So thank you for nodding affirmative. That's helped my self-esteem. I make that point not to say anything in particular about the United States, but I'm dean here in England, and I wanted to make a point, kind of a related point about the UK. So the UK does have unofficial language. It has, of course, more than one. It recognizes English and languages with, quote, equivalency. But there's been recent moves here by the conservative government to make things kind of English only, and this thought that the integration of immigrants here, you know, the UK did have once upon a time did have an empire that incorporated my original country and many others as well. And many of these folks have come back, like me, or others have come back, as it were, to the UK, and it's a country that has perhaps some kind of surprising pluralism, nothing like the United States, but surprising, and I'm going to try to surprise a little bit now. So in the move to kind of say that to integrate people better now, immigrants and established immigrant communities in the UK, they need to know English, and this thought is that that's kind of, you know, how things were. It's absolutely not how things were. About 300 years ago, with the Treaty of Union between Scotland and England, Wales was, if you're Welsh, sadly already incorporated in England at that time, and Cornwall long before that. Being British at 1707 didn't require that you were Church of England or a Methodist or nun. It didn't require that you knew English. It did require that you swore allegiance to the crown. It was more of a political allegiance, and that was effectively the glue that has kept the empire and then the Commonwealth together, as recognition of the crown. Why do I mention this point? Well, in 1707, you can be a full British citizen if you are subject to the crown and you know English, Welsh, Scots Gaelic, or what's called Ulster, officially Ulster Scots, but we'll just call it Irish, and I'll see if anyone shouts at me. And any of those languages are okay. What do I mean by okay? I mean that today, in 2021, if you want to be a British citizen, you can take, there's a citizenship test. It's I find it far more problematic than the American one, or even the Canadian one as well. But you can take the test in English, Welsh, or Scots Gaelic. And if you want to become a member of Parliament, everyone ready for this? They also recognize the right to take your oath in Cornish. Not many people do it. It's pretty rare. But that was also recognized as an official language. So for all England is thought to have English, and then it's officially the official language. It's not the only language for doing official business around here. And of course, speaking about indigenous languages in the Pequot, Mayo, my home state of Connecticut, and other native tribes elsewhere across the United States, you of course have a variety of indigenous languages here in the UK as well. And so kind of perhaps mixes some things up a bit. And in Wales, everything must be in English and in Welsh. That's not true for all parts of the UK, but true there. So one point I want to make is that, and the second point I'll make much more quickly, and that is in terms of the lingua franca and everyone speaking English. I mean, in a sense, it's an odd one. Thinking, my PhD once upon a time was on the philosophy of Hegel and looking at early 19th century German idealism. And one thing that made Kant and Hegel and others very different in late 18th, early 19th century Germany was Germany was becoming Germany from Prussia and other things that were falling apart, becoming something new. Of course, that prior to, as Kant was beginning to write in late 18th century, German philosophy was primarily done in Latin. And he thought, and others thought, that philosophy ought to speak its mother language, as it were. And Hegel and others took that, some might say, a little too seriously. I can say more about that if people want to know more about Hegel, though I doubt it. And what's interesting is that whereas there was this kind of move away from Latin as a language that kind of brought so much of Europe together and others together, the common language for everyone, and breaking into kind of everyone speaking in their own local language, it seems to be true now that wherever you look you see programs being developed, whether it's Portugal, whether it's somewhere else, just looking at the call in English. I was shocked and surprised 15 years ago or so when I went to visit in Oslo, that all the PhD students were doing their work in philosophy and political science and other topics, mostly in English, and being examined primarily in English. We hired a number of Chinese lawyers. I set up a Center for Chinese Law. I'll probably mention that, say something more about that later. But it's not just Hong Kong, where in China, where cases may be heard in English. Outside in Shanghai, other places, things do happen in English, and it's perhaps a kind of a lingua franca of I don't know if it's through the back door, but English certainly does have that grip, and what I like about it is it makes things easier for me to understand as someone who's primarily speaks English. On the other hand, as someone who knows bits of German, you do lose something going from one to the other. Some concepts, some ideas, if we think through our language, as at least some of the 19th century German idealists thought we did, that there is, moving from language to language, you think differently, language to language, and there are nuances that are missed. So it seems that there is one. It seems to be growing. English seems to be growing. There's more programs each year, not fewer, in English around the world. At the same time, I do think it's a source of some regret, and I quite like the pluralism. Thank you very much. Sorry I went so long.
Oh, no. These were fantastic introductory remarks, just like the other speakers. There's nothing like deconstructing history, because if we imagine our history in the wrong way, we will also imagine the possibilities for our future as way too English-centric. Maybe also a little personal anecdote. I think English, of course, as you've just mentioned, it has this enormous pull factor as well, right? So it's not that the state has to push us to speak English. So there might be an official rule that in Europe you are allowed to speak your mother tongue, right? Or when I tried to raise my daughter in London, I did everything I could for her to watch German movies, but the pull factors were too strong. It just didn't happen as easily as I thought. We're delighted that Professor Lima Rego is now completing this first round of questions. Over to you.
Thank you. I was hearing, listening to everyone else speaking, and I have to say my take on this lingua franca thing was a little bit different, although there are some similarities with what Thom Brooks said in the latest part of his intervention. Because I was thinking of this from the perspective of the study of law, and not so much on the perspective of the application and enforcement of law. And I would like to begin by saying that when I was a law student, once a professor told me that law is the only discipline, the only academic discipline that is strictly local. Every other discipline is global. You study science, there's the same language, even different languages, but the same scientific language. So there's a global dialogue. Not law. Law is strictly local. And I remember feeling so disappointed. I felt like I wish someone had warned me, because I would have chosen a different discipline. This is so frustrating. And then, of course, I realized that he was very wrong. And that fortunately, that was not the case. But of course, we do have a difficulty that other disciplines do not. And so, of course, I then moved on and I went to study in Oxford. And then I realized that as someone studying law, just like a piano player, pianist uses the hands as an instrument, we use the language. Of course, our brain as well, but language is our instrument. And what Thom Brooks said, it's completely true. We think with our language. So of course, when we switch to a different language, we lose something. We always lose something. I'd like to think that we also gain something by being multilingual, because of course, if we are able to think in different languages, then we enrich the end result. But for me, that was always very important to stop feeling like we are less than our fellow scientists because we are enclosed in our local discussions, whereas they are in the global stage. I hated that, and I always worked to combat that thought. And of course, now I'm vice dean at a school of law. We considered ourselves to be a European school of law that happens to be in Lisbon. And so we do want to teach. We want our students to feel like they are being taught, or they are learning how to become lawyers, not Portuguese lawyers, lawyers. Because I believe that, when we are studying law, we train our brains, and we enter a process where we slowly stop being laypersons and we become lawyers, and the brain is trained, and it becomes better and better. We become virtuosos like the piano player, but really it doesn't really make that much of a difference. So we try to have our students leave with a degree feeling that they can practice or study or teach law here or anywhere else in the world. That for us is very important. And of course, English is the language of science. If we look at every other discipline, you publish more and more in English. The top international indexed journals are mostly in English. So this is very important to us, which is why we are progressively opening more and more curricular units in English, and even entire degrees in English, because we need, of course, at the same time, we do not want to stop working in Portuguese, because as you mentioned, Alex, as you mentioned, we do have an important role to play as a country in the Lusophone world. We do have, we must understand that historically we have influenced other nations and other legal systems who still rely with various degrees of intensity, but who still rely on us and on our scholarship. So of course we have that dual role. On the one hand, we try to work the Lusophone world in Portuguese, and on the other hand, we use English increasingly as the lingua franca of science in order to enter the global stage and become actors in the global legal discussions. Thank you.
Very interesting. I just would have a quick follow-up question, if you allow me. Would you describe the legal education in the Nova Law School then as bilingual, and do you pay attention to the problem of translation? And then maybe I can also hand over this question after you to Professor Karton, who has raised his hand, since he's also from a bilingual legal background.
Well, I would say that we have an undergraduate degree that is bilingual, in the sense that we require all of our students to speak both Portuguese and English, and they must have courses in Portuguese and English, the undergraduate degree in law. Then in the graduate degrees, master's and doctoral degrees, the doctoral degree is entirely in English, and we have master degrees in Portuguese, we have master degrees in English, and we have the possibility for students to choose courses in either language. So I would say that most of our teaching is bilingual, but at the doctoral level, it's no longer bilingual, although we allow them to write the dissertation in English. The language of communication is English.
That's very interesting. Thank you. Professor Karton, you've raised your hand.
Thanks. I thought Professor Lima Rego made a very interesting point about what certainly can be the tension as educators between training lawyers for the jurisdictions where we're located. They have to learn the local law. They have to be able to work in the local courts and with the legislation and so on. But at the same time, to train lawyers who would be comfortable working abroad and would be able to be successful working either in their home country in a globalized field or in a different country. And there certainly can be a tension between those. I think just because there are only so many hours in a day, you can only spend so much time on any one subject. But what's interesting that I've noticed, and some of this may be particular to Canada, but not only, is that language, separate from legal education, language education, can be an interesting kind of Trojan horse in getting people to think globally, even if they are trained formally only in local law. And the possibly particularly Canadian angle on that is the law school that I'm in, it's in Ontario, which is a common law jurisdiction. English is the only language of instruction, aside from the occasional short course taught in French. However, for our particularly ambitious students, in particular those who are thinking about work in the federal government, hoping to clerk at the Supreme Court of Canada after graduation, we encourage them from a very early stage, if they are not already bilingual, to shore up whichever of English and French is their weaker language, so that those paths will be open to them. And in my own advising, since I teach international commercial law and arbitration, the students who are interested in those kinds of fields tend to come to me for advice. And I tell them, if you can't find it at Queen's, go somewhere else where you can find training, not just in another legal system, but in another language. Because just as you can't truly appreciate literature except in the original, not that it's necessarily worse in another language, but it's different. The same is true that law can only be expressed in language. And when it's expressed in multiple languages, those will inevitably be different, sometimes in subtle ways, sometimes in stark ways. But since we cannot have direct mind-to-mind communication, everything has to be mediated between language. And that means including and excluding.
Okay, so that sets a very nice, well, a very clear standard, right? I mean, don't rely on lingua franca as a student, but do make the effort, don't just say every LLM is out there in the English language, but specifically seek out an LLM program where you can learn a local language, open up a new jurisdiction through specific linguistic competence. I'm just wondering whether everybody on the panel would have the same advice to students, and if yes, maybe we could hear some practical examples, right? I mean, I constantly try to encourage my students, to study also in Seoul or in Malaysia, or especially pick an African country where I feel there's very little going on in terms of India-Africa exchange. I mean, how do you advise your students in terms of where they seek that sort of specialized training? Professor Lima, Rego?
Okay, when advising our students, we do not think so much on languages, but rather on telling them that they really should go abroad and have a mobility experience, not just for the language, because well, in Europe we are very fortunate to have the Erasmus program, and some years ago only a small minority of students would go. They would all be very afraid that if they were to study the law of obligations, for instance, somewhere else rather than here, that they would be handicapped if they wanted to go and work here. And we keep telling students that becoming a lawyer is not about acquiring lots and lots of contents. It's not about knowledge transfer. It's about training your brain so that you can autonomously reach the contents. The content nowadays in the 21st century, the contents are out there. They're very easily found. What we need is to train people's brains so that they can use the contents. We've had the Bologna reform quite, 10 years ago or so, a little bit more. And some people were frightened that we were shortening the degrees, because in some countries like Portugal, we used to have longer degrees. And they were saying like, oh, but life changes so quickly that we need to have the degrees longer and longer for them to be able to know everything. And of course, that doesn't make sense, because when you look at what people are hiring, they are not looking for people with 20 different LLMs. You know, they want people to be able to use their brain. And so that's what the message that we're trying to pass on. It's that it's not about all of these contents. Don't be afraid that you didn't study this or that in Portugal. It doesn't matter, because the experience that you will have if you spend one semester abroad is so much more important for you as a person than having studied this or that here or there.
Okay, yeah. I mean, I would totally agree with this. From the experience of studying abroad, you get intuition, you get a feeling for the man, you get a problem consciousness. And nowadays, of course, you have so many tools for translation. Yeah, I mean, I'm always amazed what I get from people these days when I try to look at a French case or at a Brazilian case or something. Yeah. Professor Contreras.
Yeah, so as a college student, I did study abroad, and have been obviously abroad quite a lot. But by and large, in the United States, the United States legal education system is extremely inward looking. So much to the extent that there is effectively no demand, except I think in a tiny, tiny fraction of cases for students looking to obtain expertise and skills outside of the United States, and certainly in a different language that basically doesn't exist. And there are many reasons for this. Of course, you know, our legal education system is a postgraduate degree. Many students in college for their undergraduate studies have studied abroad and done a variety of things, but the 3-year legal curriculum is fairly set. It has a lot of requirements and is geared toward you know, taking a bar passage exam at the end of it, which is geared solely toward the US law of specific states. So this is unfortunate, I think, and there are, you know, a small number of schools, of the 200 law schools in the US, probably 3 or 4, that do have a strong focus on international law and will accommodate that to some degree. So I would contrast this with China, because every year I teach a short 2 or 3 week course at the East China University of Political Science and Law in Shanghai. I teach in English, and I am pleasantly surprised by the level of competence of the students in English, both at a purely linguistic level and also at a competency in the conceptual level. One of the things that did surprise me quite a bit this last year is because of COVID-19, obviously, this is for the last 2 years has been done remotely by Zoom, just like this. And it typically is a graduate level course at that university, but for some administrative reason that I still don't understand, they decided last year to make it an undergraduate course for first-year students, so what we would call a freshman course, which is very strange because my course is on international patent litigation and standardization, which is an advanced topic even for US law students. But I ended up having to revise this and teach this as an undergraduate first-year course, which I did. And I'm not sure how much they got out of it, but they certainly did understand it, right? And one of the things, and I'm coming around to a very lengthy point here, sorry. One of the things that I observed is that the technology tools that they have available are increasingly advanced. You know, these days, back even like 2 years ago when I could travel to China, even though you go to a hotel in a remote city and they don't speak English, you can speak into your phone and they can listen to it on their phone. And immediately a simultaneous translation is appearing on their phone, and you communicate extremely well in this way. I'm confident that my freshman students in my class were having some sort of simultaneous translation, that my slide presentations, they were translating, the reading, somehow Google was translating immediately. And I think, I mean, there were some students who spoke in English quite well, but many of them didn't, yet they all managed to take this class. And I think one thing that we really have to contend with today is automation and automated translation. And it, to some degree, makes the entire question of lingua franca more obsolete, right? Google is the lingua franca. It's like in Star Trek, where they meet an alien race for the first time ever in some distant galaxy, but they can communicate with it, you know, through this magical computer system of some kind. And we will, of course, I mean, I also speak and read Spanish, and I completely agree that reading Garcia Marquez in Spanish is very different than in English. But I don't know if we need that level of subtlety for basic legal communications. And maybe someday Google will be there as the best translators, but I throw out the technology angle to this, which I have experienced in a really surprising way over the last couple of years, certainly with China.
Yeah, no, I think that's really fascinating, right? The hypothesis that the globalization of technology actually accelerates linguistic diversity. Because it brings down the barriers and costs of translation to such a dramatic extent. And I think that's certainly, you know, sort of the first intuition when we read the topic of this panel. You know, we have all these students sort of circulating between the best law school programs in the world, right? So it's nice to have this counterpoint to that immediate impression. I'd like to hand over to Professor Brooks, who I know has, you know, he's written to me
thank you very
a
much.
number of thoughts on this.
Well, I hope so. I'll give one or two, and I agree with everything that's been said. But let me give one of the kind of general points I completely get is that's been said by the last couple of speakers, has been that it is kind of noticeable with law schools how kind of different we are than other departments, where the philosophy students, the political science students, economics students seem to kind of go here and go there more easily, maybe more readily. When it comes to international students and other types of things, when I have targets from my bosses at the university on this kind of thing, the university bosses just see me as another department and wonder what's the big deal, and saying if a large group of overseas students want to come, you know, let them in, and with you know no second thought. And I say, well, you know, one of many issues is, you know, in England we offer an English and Welsh qualifying law degree. Now it's recognized in various other jurisdictions, and that's glorious and wonderful, but that there is this kind of importance on that piece of work, and that many programs, you know, the UK is perhaps not unique, but kind of a special relationship to other jurisdictions in the Commonwealth, where people can do their degree in England and Wales, and then go off to Kenya and Nigeria and Hong Kong, elsewhere, Singapore, and be able to practice there, as various systems have colonial links and so on, so forth to the UK. And also they can do the New York State Bar exam, at least at the moment they still can. So amongst others, that might well change, but we'll see. So there's an issue around some of that. I constantly, of course, tell my students that they ought to be doing foreign languages, that makes them more competitive, will open doors, all the rest of it, for all the reasons that are said and obvious to people here. However, many students then don't really take it up if they haven't already begun a foreign language. They often don't. And among my 1,000, just shy of 1,200 students doing our LLB, the UK-ish version of a JD kind of thing, maybe 10 might go abroad. I'll get lots of questions at open days. I would love to study at your university, but tell me about all your international links. And I'm looking at them, none of you are going to do it. Very few of you are actually going to take this up. I'm not as stupid as I look, right? I've been around a while. I know what's going on. But and it's a source of regret. I was constantly pushing people to do it, and I'm very keen to have more and more links. My staff are all keen to travel around and visit people, and whether it be the United States or elsewhere. And I do that. But the students a bit less so. Why? Because I think this might be common to colleagues. Because students are trying to are primarily thinking about one jurisdiction and want a job in that jurisdiction, and they're living in that jurisdiction and not so keen. Many want to be on that treadmill and connect. Not everyone. There's a maybe half are not that way and undecided and probably wisely so. But a number are on that treadmill, and end of year one, I'm going to go have my this be at this step with the big firms, and I'm going to try to get a vacation scheme, and then I'm going to try to get a training contract, and then I'm going to do something else. There's a way things go in the UK with that. So there's one issue there, and I think it is a problem of parochialism in law schools of training folks for what primarily or exclusively for one jurisdiction, sometimes with a bit of international law somehow floating along the top, as if that's something else. One thing I've been trying to encourage my students and changed our curriculum to do was to make it more global. I've kind of become a late convert to the not because I do it, just as dean and just kind of speaking to employers and seeing what the legal landscape is. When I was going to the City of London and talking to folks at all the top firms on this side of the Atlantic about what they were looking for, what's their market like, and I would hear, you're whereabouts in America you're from? An hour or so from New York. Oh, well, yeah, I was on the phone with New York, but the American market has got lots of friends. It's been very established. They got tons of lawyers. Our market is China and Singapore and to India to a degree and other places. And that's where their gaze was. And of course, London and Singapore moving in this direction as well, a big center for international arbitration and handling disputes. And so, really, the thing to do was not so much, language is hugely important, but it wasn't, yes, there's this need to kind of go out and visit and see other places. I completely agree with what's been said, wherever it is. I completely agree with that. But one of the things that kept coming to me from employers was the need of students to be, this is the wrong word, but I'm going to use it anyway, fluent in multiple jurisdictions. So it wasn't so much about the language, knowing my Portuguese from my German, from my Dutch, from my other things. It was being fluent in different jurisdictions with and we'll call it North American, so I don't discriminate or cause unnecessary upset my colleagues from my native continent, but being fluent in federal life or in that system over there, being fluent in the EU law. Britain of course has Brexit, but it is frozen in time. Almost all of the EU law. We've kind of left the EU, but not its law. Don't ask. Well, that's another topic for another day. And then looking more and more at China. And so, while I'm through our regulator, prepare students to qualify in England and Wales jurisdiction. Scotland, for those who are aware of this, is not a common law jurisdiction, although bound by a UK Supreme Court that is. I'll let you reflect on that. Scotland is a civil law tradition, like continental Europe, and so they're very different. They get a lot. Under Erasmus, they had a lot of students from the continent coming to them because the system was very similar. Whereas in England and Wales and Northern Ireland, we do much better in students from outside of Europe, the overseas students, as they were called. Then now everyone who's not British is considered an overseas student post Brexit. But being fluent across jurisdictions seems to be kind of maybe the more important thing, and maybe it's something peculiar to my market. I don't know, my undergraduate, law being an undergraduate program here, about 40% of my students are from mostly Commonwealth, common law jurisdictions outside of the UK, coming here where they can qualify there when they come back, and that's a lot comparatively in the UK, and I suspect elsewhere. So part of this element of being fluent across jurisdictions is that you have this family of overlapping common law jurisdictions where there's notable differences, and there's something kind of very beneficial in people from, who all kind of come from the same source, Blackstone or whatever you want to call it, laws of England, source on what is theft and what is a contract and all this other stuff like this, where it's developed and from the same source, as it were, but gone in different directions. Something very important intellectually and helpful in bringing people together in that sense. At the same time, the legal work, at least in the big cities for the big firms, and I suspect it's not just the case in the UK, is not just kind of doing the law here. It's going to be enough to get a job at the big international firms. It's being fluent across different jurisdictions, so, US, Canada, EU, China, as the kind of the big ones to in particular to focus on. And so kind of the Lingua Franca plural version, whatever one's the appropriate one, I'll let you tell us, Dr. Fischer, which one is right. It seems to be kind of at least as important, maybe even more important, I don't know, as getting the languages. Thank you.
Yeah, thank you so much. I mean, there's, before I hand over to Professor Karton, so we can imagine maybe, one of the things that we could speculate about is that curriculum that is more global, or the language of global legal studies, is not burdened by the idea of linguistic perfection, right? I don't need to study 7 years of Mandarin before I can work on Chinese law. I don't have to live in Brazil for 4 years and be fluent in Portuguese. But this idea of fluency in jurisdiction, I really love this idea, and that's something I'm going to take away from this comment. Unfortunately, I don't know too much about the legal profession in India, but I know that these big magic circle firms have been not welcomed in India, and they're not yet very prominent. They're trying to find their ways to the back door. But it's very interesting to see these as a factor for driving student perspectives. And sometimes I think that sort of the bias towards English that my students have when they're looking for LLM programs might be less if there was maybe a little bit more exposure of, say, a Russian firm being in Delhi or something. Yeah, I'll hand over to Professor Karton, and then we have a number of questions from the audience.
I'll try to be brief. Thank you, Dr. Fischer. I just wanted to pull together a couple of the threads that we've heard recently, which is, so I've also struggled to find the right word, like Dr. Brooks has, to describe this kind of phenomenon. And in particular, it's relevant to a lot of my research, which is on the profession of international arbitration as a field of practice. The word I've settled on is cosmopolitanism, which I see as distinct from globalism or internationalism, because those often have a homogenizing, a harmonizing kind of instinct, which in many cases is an imperial or post-colonial holdover, right? That internationalization, that globalization means the even more thorough dissemination of Western ideals and practices. Cosmopolitanism, on the other hand, is a recognition and an embrace of difference, but also the knowledge that we need to find ways to work together across cultural, linguistic, legal difference. And so what I would say, and I agree with what Professor Contreras said before, that the technology is reducing the sort of the need for linguistic homogenization. But then to follow what Dean Brooks said, it's maybe even increasing the need for cosmopolitan lawyers who, even if they speak the same language or speak different languages, it doesn't matter. They can work together with people who think differently about the law. And just one little datum sort of to support that. In my field of specialty in international commercial arbitration, it's one of very few fields where Americans are not dominant. And in fact, in particular, continental European, but also increasingly English-speaking lawyers from Asia, from Africa, and from Latin America are in many ways more prominent than American lawyers. And my pet theory as to why that is goes back to something that Professor Contreras was saying before, which is the inward-looking character of American legal education. It might well prepare people to be global lawyers of American law, right? Serving American businesses internationally, but it doesn't serve them well to become lawyers in an actually globalized profession. So I'd say that's really the role of the law schools, is even as we teach local law in order to enable our graduates to get the jobs that they're looking for in their home jurisdictions, to equip them with a sufficient degree of cosmopolitanism that it's kind of an inoculation against being a chauvinist for your home law.
Okay, thank you so much. It's almost spooky how well this leads to one of the questions that was asked from the audience. So again, I think cosmopolitanism is definitely a concept which we have to take away from this, combine it with this idea of fluency in jurisdictions. But I think it's a nice twist of thought, right? That the fact that you are from the most powerful country in the world and you speak the language that everybody else speaks in the world or tries to speak, that can also be a disadvantage, right? Sort of turns the thing on its head. And there was one question from the audience which has asked, how can we create synergies between nations or jurisdictions that don't have any sort of natural advantages with respect to the language, right? So they're not resource rich. So nobody's going to learn Russian to go there or Arabic to go there and do an oil deal. The language might not be very prominent in global culture and things like that. So can we imagine any measures, steps, how these countries could cooperate, despite the fact that in the global hierarchy of sort of linguistic dominance, they may be lower down the hierarchy? Professor Lima, Rego.
Thank you. I think I would like to depart from what Joshua Karton said, because that is so important. And I think that not having that advantage might give us an advantage. Basically, if we look at Europe, for instance, I can see that countries like Germany and France and Italy, they are more inwards looking than other countries. And so legal experts from countries like Portugal or the Netherlands, for instance, naturally, we are more outward looking, and that may give us an advantage because we are more open to multiculturalism. We are more sensitive to different cultures, and that is also something that is looked for by for instance, by potential employers. I think when they come and try to hire our graduates, because they are so young, of course, they're not so much looking for fluency in different jurisdictions, like Thom said, but they're looking for the potential. They're looking for people with that potential. And their cultural diversity is so important. If you have gone through an LLM or a mobility experience in a different culture, you have proved that you can function in different environments. And that is huge. And of course, you find that more in countries that are not as big and inward looking. So that's an advantage to explore.
Okay, thank you very much. Professor Contreras?
Yeah, the question and your framing of the question, I think bring us nicely back to the issue of lingua franca, right? I mean, for the Russian and the Saudi transaction that you're talking about, you're right. There are too many languages still in the world to operate within them all, and most of those types of international deals are done in English these days, purely for convenience and efficiency purposes. It used to be French, say in the 19th century, that these sorts of transactions were accomplished. Russian would have been used at some parts of the 20th century, but it is now English. I having worked at a law firm in Mexico City for a little bit of time during my practice, I was surprised. Obviously, Spanish is the office language, and Mexican deals are done in Spanish. But international deals, a Spanish car parts manufacturer and a Vietnamese vehicle manufacturer, they're doing a deal in English. It's not necessarily the best, grammatical English, but it is still English and it works. And neither party is ever going to come close to learning the other's language. And so these lingua francas, as social pressures create languages that are more or less commonly used around the world, these can be adopted without that much need for understanding the legal systems at the root of the language. So.
Okay. Any other suggestions how countries at the margins or legal systems at the margins, jurisdictions at the margins can maybe build synergies to move closer to the center? Yeah, Professor Karton.
One thing I would say is that we've passed, I think, through the era where globalization was the sole ideal. At least I'm seeing that in my own field. A little bit of a retreat from the idea that, for example, arbitral institutions should serve the entire globe. And I think that there's a strong place for regionalism. And I think that's especially true in regions that are linguistically diverse, such as, for example, Sub-Saharan Africa or Southeast Asia, where there's a dense population, large numbers of countries, linguistic diversity. Looking to regional cooperation can be an enormous step toward development of globalized expertise. And not only do you not have to think of a regional level as somehow inferior to a global level, but that I think that increasingly the global level will not be anything singular, but will be composed of overlapping regional blocks, you might say in sort of international relations terms, but legally. And that is, I think, exactly just in the last 5 to 10 years, what we've started to see in the arbitration world.
Okay, fascinating. So our thinking about language tying in with subsidiarity, regionalism. Okay. Professor Lima, Rego, you had another point to add?
Quickly, I wanted to add that in today's world, we live pretty much virtually, and in the global digital environment, there's no such thing as periphery. So countries that in the past were far away from where everything was going on, right now periphery is a state of mind. And if you it's a matter of attitude and of just doing things and getting out there.
Okay, I'm definitely going to write this down into my research diary as well. Periphery is a state of mind. This is really a lot of things that I'm taking away from this panel. We have the luxury of a little bit of extra time since we're the last panel of the day. At the same time, I don't want to keep people in India working too late into the night. There was one very specific question which might be from the audience, which might be suitable also for a final statement of each panelist. It's very straightforward. How does foreign language studies benefit a lawyer? Yeah, Professor Brooks.
Well, it benefits enormously. Going to a point I made earlier, we think through language, and there are differences, some subtle, some not so subtle differences in the kinds of concepts and expressions that we have from one language to the other. I'm not a linguist of any kind. I know some German, less other Dutch and other things, but you regularly come across for those who are more multilingual than I am, which I think is everyone else on the panel. There are these differences in how you could try to express some thoughts going from one to the next, and so I think that's to kind of really get to grips with some of the nuances of a legal system in a country that has a different dominant language that gives expression linguistically to that jurisdiction. It's an important element to master, to really get this to get that down. So I think there's this enormous value in that, and I'll give you but I'll state another one. That's a very academic, nerdy one. Let me give you a not so nerdy one. Let me give you one of the money of business and money. Clients don't all talk the same language. You can know all the rules you want, that's cute, but if you're going to be a practicing lawyer, your ability to interact with people, to be seen as someone folks want to interact with, is kind of hugely important. People who don't go necessarily to who has the finest detail of some point, they go to someone they trust. They go to someone they believe in. They go to someone that they've got confidence in, and someone who speaks their language. And if you're able to communicate well across a range of different clients, and knowing more than one language will help that, then you open doors for yourself in your career as a practicing lawyer that you would not otherwise be available to you. So I'll end with that practical point about money. If the students don't get the intrinsic point, maybe the extrinsic interests will do the job instead.
Excellent.
Thank you all.
Excellent. So technology is pushing us into multilingualism, and so good old-fashioned interests. Professor Lima, Rego, maybe your final answer today.
Yes, also very short. I think languages, different languages are important for different reasons. As an academic lawyer, I gave a lot of use to my, being able to read in different languages. I read in German, French, Spanish, Italian, English, Portuguese, and that of course gives me an enormous advantage. In Portugal, academic lawyers who do not master English and German are not as well regarded, because it's such an important body of literature that has been published in these languages. So reading is something, but then you need the speaking part. And for the speaking, I would say that there's a transition. In the old days, in my time, we would learn English and French, of course, for the cultural importance. And French has been slowly decaying in Portugal, and it has been replaced by Spanish. That in the old days, Spanish was so close to Portuguese that people didn't really think that they needed to learn it. But now, of course, people realize increasingly, and this is where the money comes, that if you learn Spanish professionally, if you can speak it to a professional level, you have such, the whole of South America and etc., is at your feet. So of course, but it's completely different. Being able to read and speak, they're, for completely different reasons, they're both very important.
Thank you. Yeah, Professor Karton.
Briefly, as someone who reads French well but speaks it poorly, and speaks Chinese well but reads it poorly, that very much resonated with me, that reading and speaking have different purposes. I just wanted to add something a little bit more general, but still on the practical side, which is that there is an undeniable body of research that bilingualism or multilingualism is good for your brain. There's a lower incidence of Alzheimer's in people who continue to use multiple languages into late in life. And perhaps most importantly for lawyers, whose job often is error avoidance more than it is finding a best solution. There's a strong body of scientific evidence that we are less prey to cognitive biases in a non-dominant language, in a second or third language, because anything that forces you to think twice, forces you to be rational, and you're less prey to making emotional decisions, you're less prey to making knee-jerk decisions that aren't considered. So even just for your own internal practice, even leaving aside communication with other people, being able to come at a problem in multiple languages automatically means you're coming at it from multiple perspectives. And that only makes for better decision making.
Fantastic, thank you so much. And the last answer of the day from Professor Contreras.
Well, I wish I had something more profound than to offer for the final comment, but I mean, I would just address the question about the importance of languages from two perspectives, right? I mean, so we've focused very much on the international perspective, and there are obvious reasons why. For an international lawyer or academic, other languages are essential. It is a similar but different calculus for the domestic lawyer. And I think it is becoming clear in many practices, for example, in the United States, there will not be that many US graduates, right, law graduates each year who become international lawyers of any kind, but there will be many who become domestic lawyers for whom a second language will be useful, particularly Spanish. You know, as more and more people speak this in the country, especially in the Southwest part of the country, you know, this is becoming a normal part of life, and the ability to both serve clients and serve justice in these languages becomes increasingly important. So it's much more than an issue for internationalists. It is an issue for plain old domestic lawyers as well. And I think there's value for both of those.
Wonderful. I would like to thank all of you so much. I have found this absolutely brilliant. I came into this topic worried about the dominance of English and Mandarin, maybe in the future of the world, but this panel has convinced me that there are technological, biological, economic forces all at play, also political forces, which will help me to imagine the future in a much, much more multilingual fashion. And I think also, you know, there have been given many, many good reasons why this actually is a preferable option. I'm always stunned when I walk through the university library in Heidelberg, how many African and Chinese students I see, and especially in the law section. And yeah, I think it's just a question of attitude, that you just learn a second language and you go out there and you do it without that fear. So that's also something that might be interesting to take away from that session. Well, thank you so much.